The short answer is it depends. And the reason it depends is because of the Access to Neighbouring Land Act 1992. This is a piece of legislation that says that you can get access to your neighbour's land in order to carry out works to your own land in certain circumstances. So when does the Act apply? Primarily, it applies to situations where you need to carry out what are called basic preservation works. A classic example of this would be if the retaining wall of your property, or perhaps a garden wall, is at risk of collapse and needs urgent works in order to ensure its structural integrity. The Act does go further than this though, and even in cases where the repairs aren't necessary, it can cover alterations or even improvements to features on your land, provided that it's fair and reasonable for you to have access to your neighbour's land in order to carry out those works. The key feature though is that in both cases there has to be an existing structure on your land that needs works carrying out. Taken together, what this means is that the Act doesn't apply in purely development scenarios. So for instance, if you're looking to build an entirely new structure on your land and simply use your neighbour's land to house the scaffolding to support that development, the Act won't apply. It's also important to note that even where the Act does apply, there are some limitations. Firstly, your neighbour still has to physically allow you access to the land. You can't just go ahead without consulting them. If they don't agree to allow you access, you have to go to court for what's known as an access order. If you have to go to court, a judge can set conditions on how the works are carried out and also order that you pay compensation for any loss or disturbance suffered by the neighbour as a result of the works going ahead. They can also order an additional payment where your land is non-residential. In general, compensation will be more readily awarded where the works are something other than basic preservation works. Clearly, going to court is also very time-consuming and expensive, which is not ideal where the works are needed to be carried out relatively urgently in order to preserve buildings on your property. Where the Act doesn't apply, it's simply a commercial negotiation with your neighbour. Typically, this will result in the neighbour agreeing to grant a scaffold licence in exchange for a fee payable for the access. The neighbour doesn't have to agree this, and they could simply try and hold you to ransom, but ordinarily the prospect of receiving a payment for doing nothing more than allowing scaffolding or access to their land will be enough to help you to reach a deal.